Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Well, good afternoon, everybody. And I realized I left my name tag on. My ID. Yeah, my little ID. Let me get that thing off. It'll drive me crazy otherwise. How are y'all doing? Uh-oh, I look frozen. Why am I frozen? Y'all, I shouldn't be having trouble. I should not be having this trouble, y'all. I got to reload everything. Oh, Lord, have mercy. Got to reload everything. How are y'all doing? I hope y'all are having a fabulous, fabulous day. I am excited because it's sunny out right now. Thank God the rain has ended. Honey boo! Honeybot reporting to do in initializing wait mode and on standby. Thank you so much for joining. You are fabulous. Fabulous, 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 fabulous. Update. Kerrville is digging out of the flood like everybody else in Central Texas, and we are starting to help people, and things are getting done, and it's going to be another long process, but there's a lot of people who were hit this time that said it was worse than last time. So, there you go. Okay, we're going to go ahead and hop in to Miss Davis's last day. We're going to go do this real quick, and then we're going to go into the other trial, Lindsay Clancy trial. But I just really, Honeybot is malfunctioning a little, but doing okay. Well, I'm glad you're doing okay. Glad to see you, and thanks for being here. So we're going to catch up. This was an interesting trial. This is Miss Kiana Davis, who was charged with participating in the red room of her child. And I told y'all this is probably going to end up in a hung jury, and well, it did. Let's hop on in and see what happened. We're going to zoom through some of the waiting time.
First.
Here we go. Note from the jury.
Okay. Yeah, okay. Is it 10 and 11? Okay. I'm going to ask the juror with the medical issue to write that down for me so that they candidly have nothing to do with which juror it is. And so we'll just do that. And while she's doing that,
Oh, good afternoon.
and I've just
Sorry,
written,
somebody was at my
please
door.
share your medical issue. I don't want to bring you out unless necessary. Give that to her. council, while we're waiting on that, what do we think on the deliberations?
As it relates to what?
Do you want them to continue? Are you asking me to declare mistrial? So they told us they were deadlocked fairly quickly this morning. They were out a couple more hours. They watched 2 additional pieces of evidence. They were out another 30 to 45 minutes after the second piece of evidence. The 4-person indicates the only movement is on 1 of the 7 counts, and that he characterized as possible, not on the other counts. Mr. Groove?
Judge, our position is we would ask the court to grant a mistrial in this case.
All right, Mr. Dwayne?
Well, we had an indication from regardless of what's happened in the past, now they're saying we might be able to reach an agreement at least at 1 count. But we also are waiting the note back from the ill juror, because if the ill juror has to be removed from illness, then we're starting back over again.
I mean, that would be our position would be, of course, if you're unpleased, if one juror is to be removed, they have to start completely over as to all counts.
Right. And then the question is, well, and I guess it depends on, this is a 7-count indictment. And my recollection is at least 6 of the counts were almost evenly split at the last discussion, including, let me not think back to this.
Okay, y'all, did y'all hear that? Now, we're going to get to the Clancy trial. Don't worry, but we're just finishing this up. Because of the floods, I couldn't come back and finish. They are at least equally split on 6 of the counts out of the 7. That is a true hung jury, y'all. It's not just one juror saying, I don't want to play. So they are equally split.
And count 7 last time was an 11-1 count. So you're still...
Wait a minute. The count 7 was 11-1. And I want everybody by the shows of thumbs up. How many times have we sat here and had a judge sit there and say, now, if you guys are struggling, if you're hung or whatever, don't give me the numbers. I don't want to know what the split is. I don't want to know who's voting what, just that you're hung. I don't think I have ever seen a judge discuss the split or the count. And sometimes we've even had, I think it was in the Karen Reed, where they sat there and put the split, what the numbers were, so many against, so many for, and she wouldn't even read them out loud. So what I'm wondering is why on God's green earth are they doing it here? That is hi Carol, that is highly unusual to discuss the split in front of the lawyers, us and the defendant. Hung is hung. I'm shocked.
When we talk about are we making progress, that is where we are on that last count. I think it's necessary to hear from the other juror before we make a decision. Probably. Mr. Williams, there's something else you want to add on record?
I am interested in what the response is from the juror.
I'm with you, Carol. That is very unprecedented.
Will you please
Hey, Jamala.
step in there and ask her to just say the judge wants to know if you are able to continue? Well,
Now the judge just wants to know, are you able to continue? I've never seen it done this way. I don't know about y'all, but this seems so unusual to me. In my humble opinion, I did not feel that the state proved its case, in my humble opinion, which doesn't mean much. It means zoom.
yesterday, a juror who had indicated that they're not going to change their mind, but I still think it is probably appropriate to Alan charge them before we make any decisions.
This is highly unusual. I am zooming because we got a lot to do tonight. Then we're going to come up to here.
Wait in the jury room so that we can go now. Great. Hang on a second, we're having court reporter difficulties, so we'll make sure the record's clear.
Okay, Carol, this is not the Lindsay Clancy. We're finishing up from the last day I was live before the floods hit. I'm letting y'all watch real quick the hung jury, and then we're going to get into Lindsay Clancy, and I'll explain all that in a minute.
We have questions from the jurors. Can we take a break? Of course. And then there's a second question: have a juror with a medical issue. How do we proceed? I am inclined to inquire whether they believe further deliberations will be fruitful before we try to figure out what to do about the other stuff. Do you both agree?
That's fine, Judge.
Mr.
I agree with that.
Okay.
Okay, so I'm just going to zoom a little bit because this gets just back and forth discussions with them. Basically, what happens is that the medical issue is not really that big of an issue. They just needed to go to the bathroom or take a break, take some meds. I don't know. They just needed a break.
And so we'll just do that. And while she's doing that,
Oh, good afternoon.
and I've just written, please share your medical issue. I don't want to bring you out unless necessary. Give that to her. Counsel, while we're waiting on that, what do we think on the deliberation?
That's normal.
As it relates to what?
Do you want them to continue? Are you asking me to declare mistrial? So they told us they were deadlocked fairly quickly this morning. They were out a couple more hours. They watched 2 additional pieces of evidence. They were out another 30 to 45 minutes after the second piece of evidence. The foreperson indicates the only movement is on 1 of the 7 counts, and that he characterized as possible, not on the other counts. Mr. Groove?
Judge, our position is we would ask the court to grant a mistrial in this case.
All right, Mr. Dwayne?
Well, we had an indication from regardless of what's happened in the past, now they're saying we might be able to reach an agreement at least at one count. But we also are waiting the note back from the ill juror, because if the ill juror has to be removed from illness, then we're starting back over again.
So we have the defense wants a mistrial and the prosecution's toying with, do we replace the ill juror and start over again, or is this a lost cause?
I mean, that would be our position would be, of course, if you're pleased, if one juror is to be removed, then they have to start completely over as to all counts.
Right. And then the question is, well, and I guess it depends on, this is a 7-count indictment. And my recollection is at least 6 of the counts were almost evenly split at the last discussion, including, in fact, and count 7 last time was an 11-1 count. So you're still, when we talk about are we making progress, that is where we are on that last count. I think it's necessary to hear from the other juror before we make a decision. Probably. Mr. Dwayne, is there something else you want to add on the record?
I am interested in what the response is from the juror.
Step in there and ask her to just say, the judge wants to know if you are able to continue. Well,
The other thing I noticed is, why is she verbally talking back and forth and sending him back and not writing it?
all right,
We'll see you in a little bit, baby.
let her take a break. Or him, whichever, that juror, I don't know. Counsel, if y'all step up, I don't see,
Yeah, they
and we
did.
will wait and, inquire.
We're zooming, and then they come back, and I don't think they should recharge her at this point. I think you're right. I agree with everybody that I've spoken to about this case. She may or may not have had some understanding or been there or known what's happened, but it's been so long. It's been 6 years, and I think it's going to be without a smoking gun that pops up. I don't see how they're going to get a conviction with her. Now, it'll be interesting to see the angle that they take with the boyfriend, or even if they move forward. They may not even move forward. There's a chance that they could drop the charges. You know, that stranger things have happened, my dears. Stranger things have happened.
All right, in answer to my first question, the answer is no. Do you believe further deliberation? So then I asked for the current count. I think what they've done is give me the count on, I don't know what they've done. They've given me numbers, that don't add up to 12 on 2 of the counts. So I'm going to inquire further.
Okay, guys, I have never seen a judge do that before. I have seen the floor person sit there and say, hey, we're deadlocked. We've reached a decision on 1 or 2. We can't reach on them all. We're not all in unison, but the numbers are killing me.
I think this is one of the notes that you didn't get back. Please respond.
Okay. No, I'm not thinking that. Okay, they have sent this note that the bailiff just handed me, says jurors have stated we will have the same result on Monday, no further deliberations are needed. So based on that, I'm going to declare a mistrial and excuse this jury. If you will get the alternates and let me bring them in and just give them some final instructions, then we'll release them.
Y'all, my cat fur all over it. So there's the mistrial. She's going to declare. They're going to bring the jury in. Now, we do not know whether they're going to recharge her. We do not know if they're going to go again. That is still up in the air.
Hi, ladies and gentlemen, as we've discussed, a verdict in a criminal case needs to be unanimous. As you are unable to reach one, I'm going to declare a mistrial in this case, and this will complete your service for the week. You can leave your buttons behind, leave your notepads in your chairs. You just tear those up and shred them. Nobody's going to read your notes or what have you. The clerk will have a check for you that will have a stub that will prove you were here Monday, Tuesday, Wednesday, and Friday for your employer. If you need something additional, you can contact the clerk's office or my office and we'll let you do that. I told you about 50 times not to talk about the case or let anybody talk about it with you. At this point, you may talk about the case if you wish. You're not required to, but often the attorneys may want to know what you found persuasive or didn't find persuasive or what have you. So I always let you know that it is not improper anymore for you to talk to whoever you want to about this case and your service on it. You are, of course, in no way required to do so. Make sure you get all your personal items. Leave me my buttons so I can recycle them for the next group. And Mr. Davis will show you out. Mr. Bob will show you out the back door. Okay? Thank you, ladies and gentlemen.
Just leave them in the seat.
Yeah, that's fine. We'll pick them up.
Okay, so the mistrial was declared. I'm not going to watch any more of that. We are messing up my hair. I'm looking at it backwards. We are going to now transfer over to the Lindsay trial. This is going to be the Lindsay Clancy defense. Let me give you a little bit of update on that. And give you some information. And then we'll go from there. Oh. Hold on a sec. Everything I had preset just totally bit the dust. So let me get back to where I was. I have to get everything. My bad. Um, but this case is again another child case. So if you struggle with children cases, I'm going to suggest you do not watch, or you monitor yourself and make sure that you take a break and take care of yourself, okay? That's very important. All right, let me get this. I made me a little note so I can make sure I get everything right. All right, let me go ahead and get this going. Let me close out my email. Again, thank you so much for being here. Okay, now we're getting into the Miss Lindsay trial. And in the Miss Lindsay trial, oh, I had to take a deep breath. I'm so glad you're here. So now we're going to dive into one of the most emotional and controversial cases I think we've seen in a few years. It is coming out of the Commonwealth of Massachusetts. It's versus Lindsay Clancy. This is a case that has been divided opinions from the very beginning. Now, some of the people believe this was a clearly planned triple homicide, while others believe that Lindsay Clancy was truly suffering from severe postpartum psychosis and wasn't criminally responsible for what had happened. The courtroom isn't going to decide whether those 3 precious babies passed away. Everyone agrees on that heartbreaking fact. The real question the jury's going to have to answer is whether Lindsay Clancy knew what she was doing and understood that it was wrong. This sounds like another Andrea Gates, and yeah, it does. And then, after the latest pretrial hearings, we've got a lot to talk about because the judge made some major rulings that could shape this entire trial, and we're going to watch those. So I want to start with a quick recap. Back in January 24th of 2023, prosecutors say that Lindsay Clancy sent her husband Patrick out to pick up dinner. While he was gone, prosecutors alleged that she used exercise bands, like big rubber bands, to unalive her 3 children, Cora, Dawson, and baby Kaylan. When Patrick came home, he found the children and immediately called 911. Lindsay was found outside after jumping from the 2nd-story window in what prosecutors say was an attempted self-harm. She survived but was left paralyzed. She's pled not guilty. Her defense isn't claiming someone else committed these crimes. Instead, they are arguing that Lindsay was suffering from postpartum psychosis, and because of that mental illness, she is not criminally responsible. The distinction is going to be the heart of this trial. Try not to choke, guys. Now, let's talk about what happened in the recent hearings because there was plenty of courtroom drama. The first big surprise, Patrick Clancy is expected to testify for the defense. Think about that one for a second. He's the husband. He's the father of these children, and he's testifying on her behalf. He's the one who walked into that house. He's the one who made the 911 call. Many people assumed he would be the one prosecution's strongest witnesses. Instead, nope, he's expected to support the defense petition that Lindsay suffered from catastrophic mental illness. That alone could have a huge emotional impact on the jury. The next major ruling involved the defense trying to bring in other mothers who experienced postpartum psychosis. We're going to hear about that. I don't agree with that. I don't think the way they're doing it, I agree with it. There are ways they can do it that I would agree with it. We'll talk about that more. The defense wanted the women to explain what they went through, hoping the jurors would better understand what Lindsay's mental state was. Now, the judge isn't convinced. He ruled those women will not be allowed to testify because every mental health case is different. He didn't want jurors making decisions based on someone else's experience instead of Lindsay's. Yep. Another issue was Patrick's 911 call. The defense knew how emotional that recording would be. They argued against portions of it coming into evidence. The prosecution argued it will show exactly what happened, documented the timeline, and captures immediate aftermath. Right now, it appears that the jury will hear most, if not all, of that call. If that does happen, it could become one of the most powerful moments in this trial. Then the fight over crime scene photos. As always, the court has to balance whether the pictures are more helpful or prejudicial. The judge ruled that many of those photographs can be shown to the jury, although each image will still have to be reviewed before being presented. Those images are expected to be, well, extremely difficult for everyone in the courtroom. We will not see them. And then we had what many have said have been the most memorable line from this hearing. The defense attorney, Kevin Reddington, referred to the prosecution's proposed bloodstained analysis as voodoo forensics. Yes, he's argued that the expert testimony wasn't scientifically reliable enough. The prosecution strongly disagreed. The judge hadn't completely closed the door on the evidence. So that's another issue that we'll be watching closely as trial begins. Finally, the jurors are expected to visit the Clancy home, which means they will actually see the layout of the house for themselves instead of relying only on the photos and testimony. The judge also approved the visit connecting the timeline, including the restaurant where Patrick picked up dinner. This doesn't happen in every case, so this is another significant ruling. This trial is expected to last 6 to 8 weeks, and I think it's going to come down to one question. Do y'all know what that is? Was this a deliberate or calculated crime? Or was Lindsay Clancy suffering from such severe mental illness that she couldn't appreciate the wrongfulness of her actions? These two are very different arguments, and over the next several weeks, they're going to hear from psychiatrists, mental experts, investigators, family members, and Patrick Clancy himself. As always, we will follow the testimony. We're going to break all of that down for you. Are y'all ready to get in? Are y'all ready? I'm ready. Let's get you up and rolling. I want to make sure I got the right one. Give me a second. This is a recent one, so I need this one. Is this the one from... Come on, cooperate. Yeah, this is the one I need. Okay. Why are you doing that? There we go. Show this tab. I'm sorry, this is not acting right. All right, let's get it going.
Versus Lindsay Clancy. Ms. Clancy is present. She is represented by attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Well, good afternoon, counsel. Good afternoon, Ms. Clancy.
I'm going to adjust the sound.
Counsel, can I see you at sidebar? All right, counsel. What I thought we'd do is kind of just go through kind of a list of matters that we have to. So I know we're going to talk about impanelment. We'll talk about scheduling. And then some of the pretrial matters, I want to talk to counsel in regards to if the defendant at some point is going to request to be absent from the courtroom at some point during the trial. I want to go over.
That's not confidence, no.
No, I know, the reason I wanted to raise it so that and it's not carved in stone, but if it comes
I
up,
can tell you, Your Honor, that without invading attorney-client privilege, she does not intend to
Right.
seek to absent herself at all from this trial. She'll be here from beginning to end.
and that's fine. The only reason I'm saying it is I know that was raised, it may come up, that's all. And if it comes up, it may come up because of observations I make. I'm not saying that the defendant would be requesting that, but I just kind of wanted to let counsel know how I would handle that if that came up. Then we want to talk just about, I know we've got the blood spatter motion we have to address, I believe.
Your Honor, I've changed course on that, and I've talked to defense counsel about that today. I'm no longer going to, my goal is no longer to use a physical demonstration. During prep with the witness, we realized that a series of photographs might better display the different types of spatter. So the witness is sending me photos that she uses during trainings when she trains other people, and I'll send those to defense counsel, and we should be able to agree on some photos, I think.
All right.
That should be fine.
And so with that, we don't need to address that motion today?
I don't believe so.
No.
It can be difficult if you have
I
photos.
consulted with Peter Valentin, my expert, and I told him that it was my feeling and understanding that we would not be doing the dope ad today, so I'm good on that.
Okay, all right. So we won't address that. So just, why don't we talk a little bit about impanelment and the procedure that I would consider doing is implementing a questionnaire. And I drew up a draft of one. I'll give it, we can kind of do a final talk through on Monday when we do that, but this is just so you can take a look at it. It's just 8 or 9 questions. So my thought would be have the jury come up here as a whole, give them an introduction to the case, give the Commonwealth, do we have a statement of the case?
Yes.
I submitted the final pretrial memo. I believe defense counsel submitted a paragraph that he would like read that the Commonwealth's objecting to.
All right, well, why don't we, so we'll circle back on that, and then go through the general questions with the jury, then send them back downstairs to fill out this questionnaire. My other thought is that there is an extensive witness list. And it may make more sense to have the jury be handed a copy of that list and bring that down with them when they're answering the questionnaire. Because last I counted, it was over 200 names. And I think it would be difficult for anybody to sit there and try to remember who it is. Do I know that person or not? So my thought would be to give them the questionnaire, give them the witness list, send them downstairs to fill that out. That then gives us an opportunity to take a break, line up for the individual part of the voir dire, and then bring them up and bring them in one at a time into the courtroom over here at sidebar, and just proceed that way.
I think that's a good idea, Your Honor. I would just ask that those witness lists be collected from the jurors as they leave.
That's a good idea, yeah. I have no, Mr. Reddington?
Yeah, that's fine.
All right, so that's the way we'll do that. Let me see, I have here's a draft of those questions on and we can go over these on Monday, but this is be a proposed, Don, could you hand those? Counsel.
And Your Honor, the witness list, would that be a combined list with both?
Right, and they won't be listed as defense or Commonwealth's witnesses.
Thank you.
So this is just a rough draft of the questions, and then bring them up. My thought would be to impanel 18 on this case, because it's going to be a lengthy trial. And then, so everybody's going to get, well, I know there's a motion for additional challenges. So why don't I hear you on that at this point? Mr. Reddington?
Are we going to talk about the questionnaire eventually, or?
Yeah, I'll give you two, I just
Okay. Your Honor, I have filed a request for additional challenges. I understand that would be entitled to 18, is that correct?
Correct.
Because I was told you might contemplate 18 jurors.
Yeah, we're going to seat 18.
So I'm asking, and I don't know if the government agrees, that we would have additional jurors. Obviously, that would be committed to your sound discretion. But it's the type of case, not only publicity-wise that we usually deal with, but just the sheer emotional impact that this case is going to have on jurors. And I have always felt that jurors really, take to heart their obligations under a jury trial. And I have literally had occasions where I've run into jurors from older cases, emotionally charged cases, in public places, and they would shake my hand and they cry. And that to be like 5 or 10 years later. And the impact of this case, which in my decades of trying cases, is probably the most emotionally disturbing and challenging, I think, is going to have a significant impact on jurors, more so than the usual that we deal with. So recognizing that 18 challenges might sound like a lot, I just feel that perhaps an additional number of jurors subject to your discretion would be appropriate, especially with the length of time that they're talking about, along with the emotional factors.
Come on.
I would join in the request for the additional peremptory challenges. And I just have a question in terms of if the court is going to impanel 18 about the seating of the 2 additional, because we want to make sure they have adequate viewing of the monitor and the witness box. But other than that, I have no objection.
All right, I want to consider this motion. With both parties requesting it, puts it in a little different path that you usually have on this. So, but I do understand the uniqueness of this case, the allegations. So I'm going to take that under advisement. We'll let the parties know in the next day or two. So that'll be under advisement. And in regards to the seating of the jury, my thought would be, which I've done before, is to have not to have those 2 side by side, but one in front of the other. And I think we haven't had that problem before in regards to being able to see either the witness, because it kind of lines up, and then the screen, which I imagine is going to be used here. Might have to turn it a little bit, but the cases I've done before with the 18, all the jurors were able to see. And then what we'll do is I'll just ask them as we're going through this, because everybody can see this. If you can't see it, let us know. If we have to adjust the screen or adjust the seating at that point, we'll do that. But I haven't had that problem, but I don't have them side by side like that. So, all right. Any other questions in regards to the impanelment? Commonwealth?
No, Your Honor.
Mr. Reddington?
I don't think so, Judge.
I mean, I think we've all done cases with each other. So I would expect they'll be kind of handled the way we've done it before. So that would be the impanelment. As I said, with the schedule, as I indicated over here, I'm going to tell the jurors what the schedule is going to be, but let them know that it's a fluid situation in regards to how long the trial is going to be, how long the schedule's, on a day by day. So I'm not going to be very precise, I don't think. And we'll talk a little bit more maybe on Monday in regards to how I address that with the voir dire. Let me see. The other issue that I had, just in regards to, and I know Mr. Reddington indicated that you don't believe there's going to be a request for the defendant to be absent from any of there. And so what I would, just so the parties would know, if that comes up under Rule 45, what we'd do is we'd just do a colloquy, maybe do a signed waiver, and we could deal with it that way. So it wouldn't take up a lot of time. I think it's just better for everybody to know that's the procedure that I would follow kind of after looking at the case law on that. In regards to the view, I know that I had allowed the Commonwealth's motion for review. There was a proposed order with the Commonwealth's motion. I don't think I got a proposed order from the homeowner. And I think he was invited to propose one, but I haven't seen anything. So Commonwealth, what's your position in regards to, it was your order, but what are your thoughts in regards to that?
Well, I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home and it's unlocked. We go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open any closets or anything like that or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Yeah. Mr. Reddington?
I have no position on that, Your Honor. Your Honor knows that I indicated I don't think it's necessary to have the view plus videos plus photographs, but I understand you've already made your decision on that. So it's a house that is now occupied by a man and his partner. It does not look at all like it did before when Lindsay and her family was living there. So I defer to your discretion on any specifics on the view.
All right. So my intention would be to, as I said, allow the motion for the view, issue that order in line with the proposed order that was given by the Commonwealth, and then as we go forward, we can give the homeowner a notice on that. We'll have police and security there to address any of those concerns. In the order regards to the media, we'll also deal with the no photographing of the jury during the view.
Could I just make an observation, Your Honor?
Sure.
It's a situation where obviously we're dealing with people that are either civilians or professionals. This is not a situation where we're looking at a drive-by murder in the middle of an inner city where there's danger to jurors and stuff. Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, close down a road.
Did he paint the picture? Y'all, that's the way it was for the Karen Reed trial. It was like, man, that route was all picked out. Roads were closed. It was crazy, cray. It was cray. So, do you think he is blowing this out of proportion, or do you think that police presence is needed? I personally believe it's needed. I know it draws attention, but at the same time, the jury needs to be protected. That's my humble opinion. What is yours?
Or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
Come on.
We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. You see sidebar?
Yeah, here we go. We're going to go to sidebar because they don't want the plan to be out there for everybody to know. Good choice, man. We're going to zoom. Oh, what did he say?
To do with photographs. I know, and I allowed the Commonwealth to be able to introduce some photographs. Just so, again, there's no surprises. If the Commonwealth can provide me a copy of the photographs that they intend.
Sorry, I was trying to get this thing to level up.
And to introduce, so I can look at them and make sure, no surprise, but be in line with the ruling that we talked about.
Are you referring to the autopsy photos, Your Honor?
Whatever photos, or the crime scene photos, perhaps.
We could provide you with either the disc with all the photos or it's the issue, the reason I'm hesitating is at the moment as we're prepping, we're deciding what photos to use, but that could change mid-trial. So I could give the disc with all of the photos for you to review and be prepared in case there's an argument about one of them.
I don't think there's going to be, we've already kind of had the argument in regards to photographs, and I also allowed that some photographs will be admitted with limiting instructions, but I just kind of want to make sure that I understand really what the jury's going to look at, so I can make that final determination. So kind of however you want to do it. If you want to give me all the photographs, that's fine, or just some representative ones. I'm not going to hold you to if there's one that's a little different angle from some other one, but just so I have some idea kind of what we're going to have to deal with. So.
And I can bring in copies of the autopsy photos as well.
Okay, that's fine. All right, thank you.
That would be wise.
The other thing we had talked about last time was that the 3D model was, I'm not sure if that was done or if that's an issue now or.
It's almost complete. I'm expecting to, Sean Marucci from our office has been working on that, and as soon as it's done, provide a copy to defense counsel in the court to look at. But it's going to be a digital monitor that's on the screen.
So it's a digital representation of the house?
Yes, a digital model of the home. It'll have an exterior view, and then it'll have each floor of the home. And it's just a digital model, nothing physical.
All right. So if you could just make sure Mr. Reddington sees that copy, sees that, and then we can deal with that as we come
I'm sure they will,
close to
and
it.
I have no problem with the AutoCAD stuff. I may have one myself. So it's not a
Okay,
problem.
all right. So we won't worry about that. The blood spatter motion, we're going to take that up later. What other issues do we have? I know that there's one in regards to some additional witnesses, but besides that, any other issues we need to take up?
The Commonwealth sent defense counsel several proposed stipulations. It would be helpful to resolve those.
I haven't had a chance to look at them yet, but I'm sure that I'm more than likely going to agree with all their stipulations, because if it's to avoid having people, in a ministerial sense, like somebody looked through a scanning microscope and then they handed a slide to somebody else that put it in an envelope that somebody else looked at. I have no problem with that. I'm not, as you well know, we've indicated that the mechanics, if you will, of the homicides and the actual event itself, we're not contesting. This is why you've already heard me complain about the autopsy photographs and all the gruesome stuff we're going to have to live through. But as it relates to their stipulations, I'm more than willing to stipulate to avoid having all these witnesses.
And just so the court's aware, they are witnesses, as defense has described, mostly laboratory witnesses. It would save calling 31 people.
Yeah.
So.
All right, and that's kind of what I figured was coming. So that's, I'll anticipate that there's going to be a fair amount of stipulations that'll be done. I'm not going to hold anybody to it at this point till we get the specific language in it.
My only concern is that in light of Commonwealth versus Gordon, I think there needs to be a colloquy with the defendant about the stipulation. And I haven't done one myself, so I don't have a model for the court. I'm not sure if other judges have done it at this point, but that's something, I think it would be something along the lines of other similar waivers of a constitutional right, but.
When someone stipulates to an element.
Right.
Yeah, so I'll either borrow one or draw one up. So I think that's a good idea. All right. I know that there was still a couple of remaining discovery motions that were kind of floating around. Do we need to address any of those, Mr. Reddington?
Are you referring to defendant's motion for relevant discovery?
Yes.
Okay. For the record, I would note, we're on paragraph 1, I'm looking for automatic mandatory discovery. I believe the government has been very effective in providing me with discovery. I mean, when there's a witness that's interviewed, they send me a copy of the interview. If there are notes, they send me copies of the notes, so I don't have any problem with that. I don't believe that there are any unusual issues that have been flagged on this motion, and I would ask if the court would entertain allowing paragraph 3, which is potentially exculpatory evidence, only because I know the case law, not that I doubt that they would provide me with exculpatory evidence, but I believe I have to have a motion allowed for the record to have it in play as far as the government's obligation that they recognize, and I respect the fact that they do, and expect that they would, but nevertheless, I would ask that you allow motion for exculpatory evidence, as well as motion for statements of the defendant. And again, I don't anticipate that there are extensive statements of Ms. Clancy to law enforcement. I don't believe there are literally any. And I'm well aware I have the discs of the government's doctors interviewing her, so I've already got that. But I would ask that you allow that motion as well.
Commonwealth?
So if I'm understanding correctly, from this motion, defense is just asking for the allowance of paragraph 3 and then any statements of the defendant, is that correct?
That's correct. Yep.
So I have no objection to statements of the defendant. We've provided those, and if any come to light, we will of course turn those over, but I don't expect any. In terms of paragraph 3, my concern with paragraph 3 is the last paragraph, the last couple of sentences where it says the new Rule 14 also requires the Commonwealth to inquire of each witness, officer, and agent and agency as to whether they know of or possess any exculpatory evidence. And then that last sentence, the defendant requests this court order the Commonwealth to produce each and every inquiry and each and every response.
I would narrow that, if I could interrupt you, I apologize. I would narrow that to, in the event that there are statements that disclose exculpatory evidence, the government would then advise the defense. They don't have to notify me of every single person they've talked to.
Well, I made a note of that. I was wondering the definition. I'm going to make a suggestion. Maybe if the three of you can kind of come to an agreement as to that language.
Yes.
And then I'd allow that as to make the endorsement that reflects the actual agreement instead of just kind of a blanket one that the parties may later disagree with what was meant. So I'll allow that pending the proposed language. All right.
So that would just be paragraph 3.
Paragraph 3, and also regarding the statements of the defendant.
Which I don't think is its own paragraph in here, is that correct?
I'm sorry? What?
Statements of the defendant, is that a specific paragraph in your motion? Or
It
just
would be,
general?
yeah, just as statements of the defendant in general, yes.
In general,
Yep.
okay.
Okay. All right.
And no further action on the rest?
Right.
As of now?
All right.
Your Honor, there is a discovery motion filed as well where it's a request for a 17B2.
Yeah.
Looking for state police troopers, local police detail to sit at defendant's hospital room. Government has provided me with, today, a large number of duty assignments and records and documents. I believe they're going to provide me with the state police, but I would say that motion can be tabled. They will comply with that.
So I'll take no action on that. I think that's pleading number 113, rule for motion discovery under 17B2.
Correct.
All right, so there'll be no action taken on that.
Okay.
All right. And then I think the only other kind of issue that we need to take up is the defendant's motion that was filed.
No, there are a couple more.
No, there are. Sorry.
Very briefly, as counsel had already indicated, on the document titled Joint Pretrial Memorandum,
Oh, yeah, okay.
the government said an agreed statement of facts to be read to the jury, basically alleging on January 24th, 23, the defendant strangled her 3 children, naming them and their ages, with exercise bands in the basement of their home, thereby murdering them with deliberate premeditation and extreme atrocity and cruelty. And that's the extent of what would be referred to as the agreed statement of facts by the government. I then submitted a request that Your Honor would consider adding paragraph that Lindsay Clancy denies the allegations that she is guilty of, quote, murdering them with deliberate premeditation and with extreme atrocity and cruelty, end quote, and notes that she has accepted responsibility for the acts resulting in the death of her children, however, was lacking criminal responsibility at the time of the acts as a result of postpartum depression, psychosis, and involuntary intoxication. as a result of ingestion of numerous prescribed medications. Lindsay Clancy is thereby alleging she is not guilty due to a lack of criminal responsibility and will present what is referred to as the insanity defense, which I know was one of the questions that you had put in the questionnaire.
Come on.
So, Your Honor,
Ms. Reddington, do I have a copy? Is that submitted?
I mean, we send them all to the
I
court.
provided a copy of the joint pretrial
I
memo to the
have the
court.
joint pretrial, but I'm just,
The statement of facts is at the beginning, the proposed statement of facts for the Commonwealth.
I was looking for Mr. Reddington's version.
Because I know I sent them to, I know we sent them to the court.
All right. All right. Yeah, go ahead, Ms. Brigg, I'm sorry.
So the Commonwealth would object to the paragraph as a whole. We would not object to the statement, Lindsay Clancy denies the allegations, and that she's alleging she's not guilty due to a lack of criminal responsibility. But the rest would have to come in either through her testifying or other witnesses testifying, saying that she denies the allegations that she's guilty of murdering them with deliberate premeditation and extreme atrocity and cruelty kind of flies in the face of the statements earlier that what happened is not in dispute. So that is the reason for having the evidence about what happened to Cora, Dawson, and Callan, and including the autopsy photos, because that all goes to extreme atrocity and cruelty and deliberate premeditation. And then the rest where it notes that she has accepted responsibility, again, that would be putting evidence before the jury or statements before the jury that may or may not ever be in evidence. So I think the standard, she denies the allegations, and then including what the defense is, which I usually object to, but I'm not in this case because it's public knowledge. So those two statements I think would be sufficient, and I don't think the rest would be appropriate.
All right. What I've done in past cases like this, I think the one we did a couple of years ago, was basically in the statement of the case after with the Commonwealth's allegations to say something about the question before you will be whether or not Ms. Clancy was criminally responsible if she lacked criminal responsibility. The prosecution has the burden of proof. The prosecution must prove beyond a reasonable doubt that she was criminally responsible at the time that she killed her 3 children. Any objection to that?
I do object to giving an instruction such as that, in that the case law states that we're not required to prove that she had criminal responsibility until the defense raises it. So at that point, at the beginning of the case, it hasn't been raised. I'm not objecting to it that that's her defense, that she lacked criminal responsibility, but I object to an instruction at the beginning when that evidence hasn't come in. I expect it to come in, but things change during trial. You never know. It's the same as with self-defense instructions. I object to those at the beginning of the case because it's dependent on evidence that comes in during the trial.
But then what's the basis then for asking the jury in the impeachment questions about their position regarding the defense of criminal responsibility?
Because like self-defense, we expect that will be an issue. So we want to know if it's going to affect our ability to be fair and impartial. But I don't think the instruction comes until it actually becomes an issue.
Yeah,
And I understand it's the court's discretion on that
right,
issue.
yeah. I'll take a look at them, but just so everybody, I'm probably going to give something similar to what I gave, what I just kind of read out, just to kind of tell them this is the issue. You know, this is the defendant's position that she was not criminally responsible. This is the Commonwealth's position, is that she committed a crime. And so it'll be something along that line. And I'll show everybody before we read it to the jury, so everybody can kind of have some additional feedback. But it'll be something similar to that, I bet. All right. What else? Any other issues before we get to the?
I did file a request for the court to consider, I don't know if you have it, the motion for sequestration of the jury. You didn't have that?
No.
Okay.
Have you seen this, Kamal?
I have, Your Honor.
Like I say, I know that when we file them, we send them to the DA, we send them to the court, so.
No, I have to follow my sword. It was sent to me. I had seen this one.
So the motion's left?
No, but I'd like to, just so I don't blame somebody else. It was sitting on my desk. well, Mr. Rigdon, I hear you on this.
Thank you. Your Honor, I basically can be very brief. This is, as I indicated, a very unusual case, emotionally, factually. Government's estimating 6 to 8 weeks for a trial, maybe less with the stipulation. Nevertheless, it would be a huge imposition on jurors. There has been extensive pretrial publicity, as you know, from the motion for a change of venue, which Your Honor heard and denied, which would be renewed at the time of the impanelment, depending on the way the jurors react to the questions in the sidebar individual voir dire. So my concern is that with all of those issues, and I understand that it's unusual nowadays, we don't really do sequestration of jurors. I think this is a very unusual case that may warrant that. And even if it's a possibility during the course of the trial, I think that the court should at least flag that issue for the potential jurors, for them to factor that into their own determination of their availability. So that's why I filed the motion.
Como?
Your Honor, Commonwealth objects to the motion. I think that the court will instruct, well, I know the court will instruct the jurors not to go on social media, not to read about the case, not to pay attention to any of that. In addition, the court typically asks the questions every morning. If they've been able to follow those instructions, they're presumed to follow those instructions. So I don't think sequestration is necessary, and I don't think it would be necessary to ask them about something that may never happen in the case at impanelment.
All right. I'm going to deny this. I will, said I'm going to ask the jury if they've heard of anything before, if it's affected their ability to be fair and impartial. I'm going to ask them every day whether or not they've seen anything, and also go instruct them not to view any articles or social media in regards to this during the course of that. And I'll follow up every day to make sure they follow those instructions. So I'm going to deny this motion.
Do I have to note an objection every time you deny a motion?
No, I think my denying it is to save that.
And I think there's one more motion, Your Honor.
All right. Okay, yeah. All right, what's the last motion?
Last motion, Your Honor, before we get into the jury questionnaire, I think would be caption defendant's motion for jury instruction. You have that?
I don't have that. Yeah, keep it down.
And I can give you this if you don't have it, sorry.
Oh, you have a copy?
Oh, I know, I said this, yeah.
Your Honor, when you give the instructions to the jury on the law after we've picked the jury, and I believe you do it before openings, in light of the fact that it's obvious that lack of criminal responsibility is the defense, is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in a generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she is lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect. So I'm just asking that you would add that to the generic instructions.
All right. Como?
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is the defendant still has to raise it, and they have to raise it not just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that. So that is relying on Commonwealth versus Santiago, 485 Mass 416, a 2020 case that reiterates the instruction isn't necessarily need to be given in a preliminary, or in that case, it was actually for jury instruction at the conclusion of the case if the evidence wasn't raised. But I would suggest that the idea is even stronger, that if we haven't even presented the jury with anything, then they shouldn't be preliminarily instructed on it. If Your Honor was inclined to give it because it is a discretionary thing, I would ask that you stick to the language of the model and not how counsel phrased it, because as you're familiar, the actual instruction when it comes to what the Commonwealth must prove with a criminal responsibility issue is not just whether we can say that they don't have a mental disease or defect, because the evidence may show that, but that is not the requirement for the jury. If there is a mental disease or defect, then the Commonwealth has to prove the other two prongs of the criminal responsibility statute. So the way it's phrased in the motion, I'd ask you not adopt that language and that you stick to the model if you are inclined to offer it, but we would object to the giving of it.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction. So maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
I generally give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally will give that, so I'll take a look at, but I generally give the model language that's suggested. All right.
I think that concludes the motions.
All right. And then there's one last motion that was filed yesterday. Did Commonwealth have an opportunity to review that?
Your Honor, I briefly looked it over. I would suggest that we shouldn't even broach this motion in that it violates Rule 14 discovery, and that these individuals have been identified by initials only with no other information, no statements of the witnesses, no indication of what these witnesses have to offer or the background. And it's 1 week prior to trial, so I'd ask that it just be denied on its face.
Well, I understand that, but it's been raised. So I'm going to hear from the Commonwealth, and I'll hear from the defendant first, then from the Commonwealth, I'm sorry. And then I may have to take it under advisement myself. And it may be the argument that there's just not enough here for me to make a decision is there. But I think I want to give the defendant the opportunity to argue this. So, Mr. Reddington, this is the motion to eliminate to permit testimony from witnesses who have themselves been, according to the motion, victimized by the medical system.
Okay, guys, this is huge, and I wanted to take a break here. Y'all, this is huge. What the defense wants to do, if need be, is to bring in other women who have suffered from postpartum stress or postpartum psychosis, postpartum issues, and bring them on the stand and have them share their testimony and what it's like to be in their shoes, them hearing the voices, them feeling the need to harm people, what they had to do in order to not do that. I don't think this would bode well, in my humble opinion.
Regarding the issues of postpartum depression and postpartum psychosis.
Yes, Your Honor, thank you. Your Honor, as I say in the affidavit, and as you can well imagine, I have been contacted by many people who have, in a very moving, emotional fashion, advised me of these horrific issues that they've been dealing with postpartum depression, postpartum psychosis, hearing the auditory commands, having intrusive thoughts to hurt or kill their partner or their children, infanticide, as a result of postpartum psychosis, medication issues, contributing to the postpartum depression, postpartum psychosis. And it's so easy for us as a society to say in a troubling case like this, oh my God, she's guilty, throw away the key, put her in jail and just be done with it because it makes everybody feel better. It's a feel-good reaction that, okay, somebody has been punished because of doing a very bad thing. But as we know, when you're dealing with the issues of lack of criminal responsibility, I don't like the term insanity, but nevertheless, when you're dealing with somebody who is suffering from a medical a defect or a disease, and they have actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices, the initial reaction from any one of us, I think, in this courtroom would be, come on, you're not hearing voices. What are you talking about? You're making this up. You're trying to avoid responsibility. But it is true, and it happens, and it is an affliction that people have put up with. And if they are permitted to testify as their experience themselves as to postpartum depression, psychosis, the concerns and the fear that a woman has, and I say as a woman has, because guys don't know about this. You know, we're so quick to go out and we're mighty and strong. We have many beers and we're real quick to say, throw away the key on it. But a woman who has suffered and has put up with this affliction should be able to testify and say, probably in an emotionally charged fashion, very credibly, I too have heard these command voices. I too acted on the command voices. I too have had insomnia. I too have had hedonism where I don't even care if I live or die. I have no emotion. I can't feel. I can't laugh. I can't love. I can't hate. And I think that that is important. Now, before I disclose the identity of these people, it seems to me that what I have to do is present the general legal issue to you as a preliminary gatekeeper almost, where you would say, hypothetically, I think upon sufficiency of proof, it is admissible. And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them or do whatever they want to do. But if they get on that witness stand,
Did he just say intimidate? Ooh,
they have
snippy.
credible evidence to give. So it's a two-part. I can't really give their names and addresses without knowing. You may say, as a matter of law, it's not admissible. Somebody's individual experience with a narcotic, with a drug, with a disease or a defect is not admissible in a sense of the specifics of a trial. And if that's the case, then it shuts down the issue and that's the end of it. But I had to raise the issue preliminarily.
Thank you, Your Honor. I'll incorporate what I said before about the Rule 14 and the lack of notice in the 1 week prior to trial, but also defense counsel cites no rule of evidence that would allow for the admission of layperson testimony about these issues. He cites to the battered woman statute, but in that statute itself, it refers to expert testimony, not laypersons saying, I had this experience, so the defendant must have as well. And then I think what we come to is it becomes more prejudicial than probative in that say you allow 16 people to come in and testify to that, then the Commonwealth gets to rebut that with their own witnesses, women who suffered from postpartum depression and psychosis, who did not kill their children, who locked themselves in a room to keep themselves from harming their children, who got in a car and drove away so they didn't harm their children. And so then it becomes a trial within a trial. And it's more prejudicial than probative. There's no rule allowing the admission, and it would delay the trial, in all honesty, because then we would be filing a motion for discovery on these witnesses, their medical records, having them interviewed by police, which would take time. So I would object to this motion.
I'd like to know who these people are that were locking themselves in rooms and getting in their cars to avoid killing or hurting their children.
Just go on Facebook, they're all over.
But isn't that the whole problem? I think what the Commonwealth is saying, that this isn't just a trial within a trial, it would be 16 trials within this trial. I understand the argument, especially the kind of comparison to the battered women syndrome, but as those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out. And these are testimony that'll come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that. And so I'm going to deny the motion at this time. All right. Anything else we need to address, Commonwealth?
I just think on the questionnaire, I was looking over the questions. I don't have any objections. I only request an addition. On number 2, it asks about a family member or close friend being diagnosed with postpartum depression, or generalized anxiety disorder. It also asks to include bipolar disorder, as most of the experts in this case have diagnosed the defendant with bipolar disorder. So I think it'd be important to have that information.
All right. Anything else in regards?
And also, Your Honor, there's no question on here regarding medications, whether people have any experience with psychiatric medications and whether that would affect their ability to be fair and impartial, either experience or views about. Is that the case?
All right. Mr. Reddington?
First of all, if I could just harken back to the orders that you've given on the motions in limine, and I don't mean to seem paranoid, but you, I'm sure, understand. The appellate courts in Massachusetts have repeatedly stated that on a motion in limine, if the defense counsel does not object, you're waiving it. So I just want to make sure, number 1, for the appeals court, if necessary, or the SJC, I object. And is it my understanding that any further objections, I don't have to keep objecting because I respect your ruling that I don't have to have?
Come on. I have no problems with that. I think it's clear that the issues were raised on the motions in limine. I've ruled on them. And I think there doesn't need to be a recurring objection on those.
I would agree, for the record, Your Honor, that if whichever party was affected by the denial, the objection is there.
Okay, all right.
All right, addressing the questionnaire, Your Honor, if I may, it's an interesting issue that we're dealing with. The questions that have been requested, have you, a family member or close friend, ever been diagnosed with postpartum depression, or generalized anxiety disorder? The next question is, skipping over the NGA, number 4, have you, a family member or close friend, ever been diagnosed and or treated for mental illness or condition? And then going down to number 6, have you, a family member or close friend, had an experience with a psychiatrist, psychologist, or mental health facility that would make it difficult for you to be fair and impartial in this case? And finally, number 9, do you believe that a person's mental illness should not be considered when determining their guilt or innocence? So, going backwards, number 9, this is very similar to when we ask jurors or we tell jurors, do you understand that a defendant does not have to testify in this trial? Do you understand a defendant does not have the burden of presenting evidence on his or her own behalf? And many times at sidebar, jurors will say, well, I think they should tell their side of the story. And then the judges will say, well, if you are instructed by me that that is not to be considered, can you then abide by my instruction and be fair and impartial? And they always invariably say, well, yeah, I could, I guess. And then they will be accepted. I'm concerned about raising all of these so personal issues. There is a stigma in this country of mental disease or illness. There is, whether we acknowledge it or not, and it's embarrassing to many people. And I'm just concerned that jurors would, let's say they answer yes to question 2, that you or a family member has been diagnosed with PPD or depression or generalized anxiety disorder, and they say yes, then that's going to open up the inquiry into when, where, how, who, what medication, and will then invariably lead to kind of an inverse challenge by repeated challenges by the government, I think, to pretty much any citizen who comes in here. It's almost like a reverse Batson challenge. Any citizen that comes in here and has had mental treatment or has had what they perceive to be a mental disease, and they have been on medication, they're going to say hypothetically, yes, I have, and I saw Dr. So-and-so, and I think that the shrinks are useless, and I think they're terrible, and I think they're horrible, and they ruin my life. They're gone. They're going to challenge that person. If a person says, yes, I had medical treatment by a psychiatrist and I was on medication, that begs the question, how did that work out for you? Was there any issue with the medication? Anyone that has any issue whatsoever with mental disease, defect, or medications is going to be tossed because of alleged cause. They're going to say it's for cause because they have a preconceived notion. And that's going to wipe out a significant number of citizens that are being brought here to this court to sit on a jury, recognizing the fact that the issue of mental disease, defect, treatment, lack of criminal responsibility is central to this case. I certainly have no problem, and I have confidence, as we always say, that the court will give a very forceful instruction to the jurors that regardless of any preconceived notions, that they come into this court with a clean slate and they have to listen to the testimony and listen to the evidence. We do it all the time, usually to the detriment of the defense, but we do it and we say, okay, can you understand what I'm telling you, that you don't have to listen to this, or that you don't have to feel the defendant has to present their evidence, and we accept them as jurors. So I don't think it's fair to exclude a potentially significant number of people that would be good citizens, good jurors, just because they have had mental disease or treatment, psychiatrists, psychologists, MDMA, or whatever they call it, or any of those treatments, or medical issues with medications. I just think that we're flirting with disaster on that type of question.
So what would you want me to just ask number 3?
Number 3, looking at number 3, I think is fine. The defense in this case is that Ms. Clancy is not guilty due to not being criminal or lack of criminal responsibility. At the time she killed her 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? And then they come up on the individual voir dire and they say to you, in our presence, yes, I don't like psychiatrists, or I don't like psychiatric medications, or my brother did something or other. Yeah, I think question 3 captures it. Instead of going through all of those questions, number 2, 4, 6, 9, I think number 3, I have no problem with.
Kamala?
Your Honor, I
That
think
was
the
a lot.
questions should remain as they are. Defense counsel's only objection to them seems to be his belief in knowing how we're going to make decisions and how we're going to address issues or answers that come up at sidebar. And he is wrong about our approach, and he is wrong about the way we handle things. I can speak for myself, and I can say that if a person comes up and says that they have had mental health treatment, mental health medication, I have no issue with that, as long as they can be fair and impartial to both sides. And I mean both sides, not just me, to the defense as well. Now, his example that he gave, that someone says, I had an awful experience with a doctor, it ruined my life, and I can't be fair and impartial. I should think that neither side would want to take that person, because we want a fair and impartial trial for both sides. So I think the questions are fair. I think the questions get to the heart of the issues that will be in this case, and I think a lot of them get to the issues that case law in this area addresses we should ask about. So I'd ask that you leave your questions as they are.
All right, I'm going to take a look at it. I don't think I'm going to go just with 3. But I may combine, there are a couple of kind of just going over the same kind of area. So I think if I can condense those, that's probably what I'll do. And I'll give parties the chance to be heard again in regards to that. So it'll probably be 3 and then maybe one other one addressing that kind of issue. All right, anything else?
Would you want to consider adding the question of, do you understand that a defendant does not have an obligation to present any evidence or testify?
Just so everybody knows, what I'm also going to do is, after we have the questionnaire, I'm going to bring them up, bring each juror over to the side, and then I'm going to ask, some additional questions, including defendant not having to testify,
Okay.
and understanding not having to present any evidence.
Yep, that's fine.
Questions about police credibility, all those type of things that I would generally ask. I was just having the questionnaire because these are kind of issues that those type of questions in the questionnaire, it may be easier for people to go and kind of reflect a little bit instead of just standing up here for the first time, being hit with these type questions in front of us. So I will ask, defendant does not have to testify. The defendant has no obligation to present any evidence. The police credibility question, kind of things along those lines, I'll ask over here. And then the parties can have, reasonable follow-up as well. All right?
Thank you.
Anything else?
Finally, you gestured to that side of the bench. Would the individual voir dire be?
The individual voir dire, that's just by force of habit.
Okay.
The individual
I was gonna
voir
say,
dire,
we
as we
need that.
discussed before, will be
Yep.
done over here.
Perfect.
Defendant will be here, sidebar.
Okay.
And then, and that's part of why we're going to take that break, to have the jury go back, fill out the questionnaire, then we'll set it up for the individual voir dire. We'll do that over here.
Okay, thank you.
Okay. All right. Now, anything else?
Not for me.
All right, Como? All right, well, thank you very much. We'll see everybody on Monday, 9 o'clock. We'll begin the impanelment. As you know, it'll probably take a little while before we get the jury up here, but so if there's anything that we have to address before I go talk to the jury, we can do it then. All right?
Thank
All
you.
right, counsel, thank you.
Thank you.
Wow, what did you think about that? I'm going to gear up the next video. I'm going to gear it up. Come on. There we go. I'm going to do some switchy swoop. Switchy swoop. Switchy swoop. There we go. So this is very interesting. I'm really getting involved in this case, y'all. There is so much there. I do not think that they should bring up people who have suffered or have mental illness to the level that this woman has, that they wanted to bring in, who are not professional witnesses, because I don't want them re-triggered. I don't want them getting up on that witness stand and being torn apart and fall apart. I mean, that's just a disaster, in my humble opinion. I'm not an expert. I don't know those things, but in my humble opinion, she is a forensic pathologist with the ME and a few years, but just does consulting and has only done that for 20. Wow. Okay. So this is today. Okay, guys? This
All
is
right.
today.
So before we begin the impanelment, I know that there was a motion to eliminate filed
by the Commonwealth last week, and it was and it's pleading number 129, Commonwealth's motion eliminate to exclude defendants' undisclosed expert witnesses. So I've had an opportunity to review Commonwealth's motion and the attachments. I've had a chance to review the defendant's opposition. And so why don't I hear first from the Commonwealth, and then I'll hear from the defendant. Commonwealth?
Thank you, Your Honor. The Commonwealth's moving for the court to exclude the 4 expert witnesses detailed in the July 7th witness list defense counsel provided to the Commonwealth, or in the alternative to continue the trial so that we can prepare for those witnesses. We received that witness list on July 7th. There were many nurses and doctors on that witness list, many of whom have worked with the defendant in the past. So we weren't clear as to whether the doctors were people she had worked with in the past or if they were experts that we weren't aware of. So we emailed defense counsel asking for information about these experts or these doctors, and he responded pretty quickly. I know in his memo, he says that they're not experts, but they're clearly experts. They're not fact witnesses. It doesn't appear that they knew her, worked with her, observed any of the events leading to these charges. The subject matters that the defense lays out in his notice and in his memo are subject matters that lay witnesses would not be allowed to testify about. Things like mechanism of injury, mental health, medications that are prescribed and the effects of those medications, and psychiatric standards of care, all of which would be expert witnesses. Now, defense counsel is an experienced attorney who understands the rules, and by providing these names at this last minute, a week and a half before trial, was a strategic and intentional act to surprise us with these witnesses and not allow us to be prepared for them. We have a right to prepare for witnesses, to obtain materials, especially with expert witnesses, to find out where have they testified before, what publications have they written, what is the basis of their expertise, and to get rebuttal evidence and or witnesses to be prepared for trial. If the Commonwealth had attempted to do the same at this last minute and bring up expert witnesses, they would be excluded without question. And I know the standard is different for prosecutors, but we all still have to follow Rule 14. And to allow defense counsel to call these experts would be fundamentally unfair to the Commonwealth.
All right. Yeah, Mr. Reddington.
First of all, I can't remember the last time the government, let alone defense, was excluded from presenting testimony by way of, quote, experts, end quote. Generally, it's a matter of fairness. What are they going to testify to? Does the government, in this case, they've got like 39 people working on this case, Judge, and to suggest that they need time to prepare for cross-examination of fundamental witnesses that depend on the direction of their case. For example, I have an emergency room doctor. He's a board-certified emergency room doctor that I consult with to help me understand and interpret the medical records, the extensive medical records. South Shore Hospital dealing with the initial admission and the injuries. Brigham and Women's Hospital, she coded on this fake suicide. She coded and almost, and literally her heart stopped at Brigham and Women's Hospital. I need to know terms that I don't understand that this Dr. Velkovich is going to assist me with and has been assisting me with them. Now, I don't know what the government is going to say in their opening statement. So I can stand here right now and tell you, in all likelihood, I wouldn't call Dr. Velkovich as a witness on this case, but it depends on what they say in their opening statement. In the event that after their opening statement, there are issues in play that I feel I would be calling the doctor, I certainly would supplement. And they've already got all their CVs. I've already given them the CVs. As it relates to the psychiatrists, I've given them the CVs. I've given them voluntarily videotapes of their interview and evaluation of Lindsay. I have given them their notes. They've got every scrap of paper that my doctors, that would be Dr. Zeitzel, Dr. Resnick, and Dr. Spinelli have. As it relates to, for example, the other doctor that's referenced in the defense disclosure to the government, Dr. Condi. Dr. Condi is not one of my experts. Dr. Condi is an individual who filed an affidavit dealing with the atrocious failure to have medical care that is consistent with the standard that is applicable, and that's in the civil suit. I summonsed him. He doesn't know me. I haven't sat down with him and gone over evidence and everything else. I said, you're a witness in that case. You filed an affidavit. I'm summoning you, and I did. I have spoken with him, and I gave the government the affidavit that he filed in the civil suit. You then have my crime scene, if you will, blood spatter evidence. I don't expect that I'm going to be calling Dr. Condon. But when we got into this thing where they wanted to have whiteboards and drop, fluids on it and experiments in front of the jury, you remember that I objected, filed an objection, filed a brief, and indicated that I wanted a Daubert hearing. Your Honor allowed that. I then spoke to Mr. Condi, Dr. Condi, I should say, who I've dealt with before. Very, very well-known crime scene reconstruction gentleman. Very qualified, board certified, on the boards and all these things. I'm not going to use them because we, as you know, are not going to be doing the experiment on the board. I am still going to consult with him as it relates to evidence that I think I have to ask him questions about. But right now, as I stand here, I don't expect to call him. So that's Dr. Condi on the affidavit on the civil suit. My crime scene blood spatter expert. I have my board certified emergency room doctor, and then I have Dr. Laposada. Everybody knows Dr. Laposada. She's no stranger to the courts. I've used her on many, many, many murder cases over the years. Dr. Laposada, as I stand here now, I don't know if I'm going to call her or not. It depends on, again, what the government argues in their opening. If they argue something in their opening that opens the door for me to slam them with Dr. Laposada, you can bet I will call her. But they don't need weeks to prepare for cross-examination. That's ludicrous to suggest that. So I think I have complied and then some with Rule 14. So I'm asking that the court, not at this early stage, strike the witnesses because I don't know if I'm calling them yet. And if I do, they'll get a report. They already have all their CVs.
Yeah.
I may, Your Honor.
Ms. Sprague, please.
We do not have 30 some odd people working on this case. It's ADA Buckingham and myself working on this case along with our victim witness advocates. We've never made an allegation that defense counsel hadn't provided discovery pursuant to Rule 14 in a timely manner for the 3 experts that they plan on calling regarding criminal responsibility. What we're talking about are the 4 witnesses he's detailed in this last minute notice of witnesses. And when he says that Dr. Condi is just a witness, he's not an expert because he's in the civil case and he hasn't talked to him, that doesn't mean he's not an expert. He's clearly an expert because he's talking about medical information, psychology, and medications, and the psychiatric standards of care that only an expert would know. And we haven't been provided anything but his affidavit, and his affidavit doesn't even state which standards of care is he talking about and what he bases his opinion on. And most of his opinion is more likely than not. So there's nothing in that affidavit that would be compliant or would fully comply with Rule 14. In terms of Dr. Laposada, yes, I am familiar with her, and often in cases when she testifies for defense, she files a report at the last minute, giving prosecution little to no time to prepare for what she's going to testify to. We have nothing on her or any of these other witnesses as to what they plan to testify to, what their opinion is. There are no reports, no notes, no statements. Those are all required information so that we can be prepared so that the process is fair. And defense has to follow Rule 14 as well.
I mean, I understand the defendant's kind of argument that not knowing exactly what the evidence is, it's difficult to say what witnesses you're going to call. But at this point, the Commonwealth has presented their experts and what the opinions are. The defendant has provided significant discovery regarding the 3 experts regarding criminal responsibility. The other issues it's almost like it's premature at this point to rule on this. I mean, if the Commonwealth's witness comes out of left field and gives an opinion that is completely different than what had been disclosed, that's a different analysis than if the witness says, I've been saying this for 2 years. I think that's a different argument. So I don't know yet. I'm assuming that the witnesses that the Commonwealth is going to call will testify consistent with what their opinions. And if that's the case, I may very well allow the motion to eliminate. But at this point, if they varied significantly, then I might have to view it a different way. It's a difficult motion in regards from the defendant's standpoint because I don't have any opinions. Like Dr. La Posada, I don't know what her opinion is, right? I mean, it may be completely going along with the Commonwealth or against the Commonwealth. So it's hard to deal with that. Same with, well, Dr. Condi, probably not. Is it Dr. Condi? He's going to testify regarding the standard of care. I'm not sure if that's going to be any different than what the defendant's other expert is going to testify to. And it was already an expert who's going to opine in regards to that. The other is Dr. Valentin, but that doesn't sound like that's going to be an issue because it doesn't sound like the Commonwealth is going to do the seek to introduce that demonstration. It was that Dr. Volkovich. And same with the emergency room doctor. I don't know if anybody's even going to disagree with each other, you know? So I'm going to allow the Commonwealth's motion at this point, subject to it being renewed based upon what the evidence is as the case develops, if that makes sense. The Commonwealth's motion is to exclude the defendant's undisclosed expert witnesses. I'm going to allow that at this point, but I keep using the word allow, but allow the defendant to renew that depending on what the Commonwealth's either opening is, as you said, or what their experts say. If they say something that's unexpected.
The problem, Judge, respectfully, is that it hogties me on my opening, because I don't know until they make their opening if, for example, I would utilize Dr. Volkovich. I just don't know until I hear their opening. So if you're ordering me that I can't reference these witnesses or what their opinion would be, then it puts me in a very awkward position.
Well, it's not that awkward because you've got a situation where you're telling me you don't know what they're going to say. So how?
Because I can anticipate what they're going to say.
No,
I have their prior statements that they've made. I've got their various releases. I've got their Raymond argument. I've got all of that. So I have an idea what they're going to say. I just don't know they're going to say it or not.
Well, we go first, so then he'll know.
Well,
And then he
exactly.
can tailor his opening to that.
Here's what we're going to do.
So when
Here's what we're going to do. We're going to do just what I said. All right. I'm going to allow this motion subject to the defendant as the Commonwealth's case changes. Or if you want to come up
Yep, that's what we'll do.
after Commonwealth's opening, if you feel that has opened the door in some way,
Yep.
I have no problem
That's fine.
hearing everybody over here. And same thing as the case unfolds. If you feel that something is said that's was unexpected or inconsistent with the earlier disclosure, by all means, come on up to the sidebar and we can talk about that. Okay? All right. Anything else we need to address?
No, Your Honor.
All right. So what I'm going to do is I'm going to get off the bench at this point. We'll bring the jury up, the potential jurors up, and then we'll begin impanelment as soon as we get everybody up here. Okay?
Okay, y'all. Yes, I'm having hibachi steak and chicken. Yep. Okay, so yeah, this is going to be a phenomenal case. I hope you join me. And they did seat, as June so lovingly told us, they did seat 3 women, 2 men on the panel, and they'll be seating them tomorrow. I will come live tomorrow if we have something to go live on. Okay. because I want to try and I have a funeral this week. I for those of you who don't know, one of my spiritual mamas passed on, and so I'm going to have to try to figure out how to navigate all that this week. But I'm hoping they have it more earlier in the day. Sometimes it's been busy around here, so sometimes it's late in the afternoon. But if they have seated everybody, we'll come in and start watching live. I might just do some shorts and catch all up on what the numbers are, so I definitely will be doing that. Thank you very much. And for some of you who don't know, who may not have seen my live, the gentleman that died from the floods in the mobile home, I knew him and his wife. I spent 4th of July with them. We were a big group, but yeah. So, so what I'll do is I'll do some shorts and keep us posted on the numbers as soon as we know them. And then when we go live for court, we'll be live every night. Now, you got to understand, and I need everybody to hear me. I have a full-time job. We're dealing with a flood. I'm a full-time college student. And I got all this other stuff going on. So I will be live as much as I can be. And there might be a night that I can't go live. We'll catch it up. This trial is going to be long enough that we can do that. If I don't have anything going on a weekend, I'll go live and catch up on the weekend. So I think this is going to be a live that we're going to be able to really dive into and enjoy and get some things going. So with that, everybody have a fabulous evening. My mods, Miss June and Honey, thank you so much for being here today and helping me out. Greatly love and appreciate both of you. And all of to the new people and the lurkers and those who've been with me a while, thank you so much for joining. Everybody, go have an early evening. Love on your families. 4 to 6 weeks. That's right. Love on your family. Tomorrow is never promised. And don't go to bed angry, guys. It's not worth it. It's not worth it. So click the bell. Make sure you give me the thumbs up and click the bell so you know when I go live. And I will be doing shorts and keeping us posted on the jury selections. Okay, guys, it looks like we got a good case. Thank you so much for the loving. Y'all have a great night. I'm going to eat my dinner. I'm going to do my college work and get caught up because he gave an extension. Yes, Carol, we may have a hurricane coming our way. Now, the thing is if it hits anywhere near Houston, we have a high chance of rain. And we can't handle any more rain. It's really going to have to dry out, but even then it doesn't matter. So anyway, y'all be safe. Have a great evening. I will see you soon. Good night. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.